I do want to welcome Ms. Mars Galloway from the Confederate Tribes of Warm Springs, I think is with us. Mars, do you want to come on voice? Say hello.
Hello. I think my video is being a little funky. My name is Mars Galloway. I am the Cultural Resources Department Manager for the Confederated Tribes of Warm Springs. I've heard a lot of really great remarks. Oh, hey. I've heard a lot of really great remarks about like accessibility and communication, education and relationship building. I think those are going to be essential. You know, we all do good work together. Um, the final product is always going to be so much better than, if we just do something on our own. I really appreciate some of the comments in regards to like representation of landscapes as they are related to cultural resources. I think, coordination, especially when we're talking about tribal representation, the tribes have been here since time immemorial. Some of these places, these landscapes, they're essential to the cultures and the communities that exist today. And so here I am representing, I guess, the Confederate Tribes of Warm Springs. So thank you so much for having me. I'm looking forward to participating.
Thank you very much. Thank you very, very much. And I see Ms. Carrie Miller with Confederate Tribes of Umatilla Indian Reservation. Carrie, welcome.
Thank you. Thank you, Kristen. And, all of DLCD for, your hard work to make this happen. I think this is a really big day for these issues moving forward, something that we had hoped for a while. And so to be able to work through this process to this point, to be able to have a RAC and, start to develop, these rules. So, my hope, in this rulemaking is to really kind of outline a process so local governments, can make meaningful assessment of impacts of these projects that they're reviewing or zone changes or whatever the action is, on cultural areas. So cultural resources, cultural areas, let's look at defining this broadly to incorporate all these places that are important, or at least to have the discussion about how might we do this. Because in the past, I don't think there's been kind of a clear process for government. So I think if we can outline steps, I've heard about educating others, building these relationships, because I think part of it, as we'll get into this, is about needing to talk with one another about why these places are important, why these sites on the landscape are there, and what recommendations can the local governments make to protect these important places. So I look forward to rules that would sort of outline this process. So as people change through time, in these government systems, that says, okay, here's what we should be doing, who we should be reaching out to, and how can we capture these important places. So thank you for having us all here today, and appreciate it.
Awesome, Carrie. Thank you very, very, very much. Great to see you. For sticking with it. I know folks are like very long game on this. And want to also welcome Ms. Gabby Pratt with Cocoa Indian Tribe. Gabby, would you like to come on and say hello? Thanks for making it.
Hi. Yeah, thank you for for allowing me to be here. Gabby Bratt with the Cocoa Indian Tribe as the Cultural Resources Specialist. I attended like the previous Goal 5 meeting, and so I'm happy to kind of continue on and pass on anything and everything we talk about to supervisors. And yeah, just kind of to everyone else has to echo what everyone else has said about like developing and maintaining relationships, whether existing ones or with new ones with like local, state, county agencies and offices, and just making sure that not only the archaeological belongings are protected and taken care of, but also the living cultural belongings like the gathering places, the landscapes, everything, that they're also well taken care of, and make sure that we're all in partnership with each other. And yeah, so thank you.
Gabby, thank you for making time. The opportunity cost on everybody's time to be here today is very real. So we'll move along at a clip. There is a phone number on ending in 129. if you'd like to introduce yourself, we'd be grateful.
Good afternoon. This is Peter Hatch from the Confederated Tribes of Siletz Indians. I'm sorry that I am having trouble with my Wi-Fi today and having to call in, but I'm very glad to be here. I work for the tribal government as a history and archaeology specialist, and similar to Gabby, have been involved in the previous meetings, and I'm happy to continue. I'm really glad of the depth and breadth of experience that is gathered in this room. The number of field colleagues that I respect a lot who are here, and folks that I am meeting on this meeting for the first time. It's humbling for those of you who have been involved in many RACs before, going back a long way. This is my first rodeo, so I'm excited to dive into the process, and want to thank Amanda and DLCD colleagues for doing so much to put this together. All right.
Awesome, sir. Thank you very much. Sorry for that. Thank you. Well, thank you for overcoming the technology challenges. Those are never fun, and it's just great to hear your voice. I always feel better when you're in the room, and everybody gathered today. It's a really wonderful wonderful gathering. I wanted to just share, I think I'm sharing not quite correctly, but this Curry Gill's statements. Amanda, do you mind coming on and just summarizing anything from Curry, or would you like me to do that?
No, I can do that.
Thanks.
Happy to. So well, first, good afternoon, everyone. Thanks for being here. So what Curry shared with us is that she would like to highlight that all communities have culturally significant places and practices, and that it's important to develop strong engagements with identity-based organizations and people who have not understood how to use land use decisions, or have not understood how land use decisions have impacted their community. She recognizes that tribes have experience, or at least more experience, interfacing with state and local land use programs, and it will be important to reach out to other identity-based groups so they kind of understand what we're talking about, what we're trying to do. Cultural practices and places don't have to include archaeology. Archaeology has protection from a variety of existing state laws, and it's important not to conflate protections for archaeology with protections for sites that are important traditional for traditional practices. So leading up to this rulemaking, Curry had heard reference to process and criteria integral to the National Register of Historic Places, and local land use is very different, and she feels that this distinction is important to this rulemaking.
So Amanda, thank you. I think I just went by Keenan's. Would you like to touch on Keenan's, or?
Yeah, I'll go on to Keenan's. All right, so Keenan is a land use attorney with Schwabe, Williams, and Wyatt. He represents developers, special districts, and individuals in all facets of Oregon's land use system. Keenan is motivated to have a seat at the table for this rulemaking to ensure that the rules for considering Goal 5 cultural areas are crafted in a responsible and reasonable manner, accounting for the practical realities of land development and conservation, while ensuring the intent and purpose of Goal 5 is met. Not only will the rules adopted for Goal 5 cultural areas have a lasting impact on land development and conservation throughout the state, but the rules will also impact Keenan's law practice and the lives of his clients. Therefore, he's motivated to provide his perspective and technical expertise for this important rulemaking process.
Thank you. Thank you. Would you like to say any words, Commissioner, after hearing that whole round of introductions? We are about to transition, but I know I moved, but I have the mic. I'm ready to give it to you if you'd like to say anything.
No, this is, what a good smorgasbord. I mean, I don't know that there's anything we're missing, except perhaps that idea of other cultural entities.
Mm-hmm.
And so I'd like to hold that and consider it, because I think that's worthy of perhaps expanding the table.
That's right. Thank you. And Amanda has done some outreach, but I think we should continue it. There's two things that, many things, thousands of years of history that happened before this rulemaking, and also, just a few years worth of work preparing, but a couple years in the preparation, we were advised by, some of the tribal representatives here today, and also not present, but still great value, to reach out to local governments to see what's happening on the ground already in their communities. So I want to just, in absentia, thank all the respondents to that survey. We could certainly share a summary of that survey, but one of the things that was so clear there is that local governments wanted more information and more help. So that was very motivating. Another that you've heard us reference is a work group of tribal representatives that are commissioned us to work with in preparation, which was very helpful because this isn't a normal area of work for really most of any of us. And in that, we asked the tribal representatives at that work group if we should focus just on the tribal nations or other cultural groups, cultural identities in Oregon, and they said absolutely the latter, and they were very inclusive in that regard. So I just want to commend work group members for being so inclusive that it's not quote unquote just about tribes or the first inhabitants of Oregon, but all kind of culturally identified groups today. So we'll keep that open and continue to do that outreach. Thank you, Commissioner. Just really quickly on the charge and charter, you have all this, so you know what you signed up for, so I'm not going to go over it. This came from the commission. They adopted it in Medford. They're meeting in Medford just 2 months ago on November 22nd. It's in your packet. So if we get lost, this is our North Star. And the commission looks forward to hearing back from us with some draft rules. Knowing that we need to do this work this year before the legislature gets going again, we are going to be, from Amanda's good work and working with partners at SHPO, presenting a draft rule at our next meeting. So that is quicker than usual. We've looked to have just 4 or 5 meetings of this group that we can squeeze into this year before the first public hearing in September. So if we need any guidance, that's there for you. It's in your packet, it's online. So I might focus our time instead in terms of just the charter and see if anyone has any questions or concerns about that. It describes the purpose of our group according to that charge. RAC members, tribal, state, and local government representatives, as well as land use and community development interests. We will provide committee support and our commission liaison to this work, and Commissioner Thompson. Hoping everyone can make a good faith effort to attend. Thank you very much for doing one more doodle poll and probably a few more before it's done. I know those are taxing. We look to meet either, about every 4 or 5 weeks or no longer than 8 weeks apart. Until the adoption of a new rule, fingers crossed, but because of the collaborative nature of the meeting, we're hoping that members can work to attend consistently. We'll prepare meeting summaries and draft and final, but we'll ask RAC members to communicate any corrections within 2 weeks of the published date of the draft. We'll post finals on our website, so we don't take time in meetings going over meeting minutes. But if there are errors, please do let us know. We are, there's a section there on decision-making and commitments. And members are encouraged to communicate your guidance at meetings or in writing. So don't feel that you have to if you didn't express what you'd like to express in the meeting time, please do feel free to email us, and we'll probably ask you if you'd like that distributed to the whole RAC or not, or if that's just for staff, but communicate. We certainly could entertain a majority and a minority recommendation to the commission. And just a note there that tribal representatives' participation we don't expect that to take the place of formal consultation, which is always a right and an expectation in state and tribal relations. We hope, and this is the one slide we kind of pulled out of here because this is my personal favorite. We hope that you will bring up any concerns at the earliest point so we can address them. To share all the relevant information that will help each other, help this group achieve our goals. Keep your organization's leadership informed of recommendations or your governments, and then review and comment on draft and revised rule impact statements and other strategies. I will say, just here for the record, I think that this will be a program no rule changes the world on its own. So it'll be a suite of actions, responsibilities, agreements, behaviors, rules, funding, hopefully, that will help implement new ways of doing work in Oregon in this regard. So we expect that you really think about this in terms of a program with kind of a rule, this rulemaking as centerpiece. If you do represent yourself outside this RAC meeting, I would just say, if you don't mind, just representing yourself as a person instead of the whole RAC. And if you are contacted by the media, of course, there's freedom of speech. But if it's specific about the process, please refer them to me or to Elliot or to Saria, and we will kind of quarterback that to our commissioner or director as they wish. There's some process, requests there that we agree to apply the following: to listen with respect, seeking to understand each other's perspectives. Commissioner said it, we have an amazing representation here, people bringing real concerns, lived experience. So let's really do listen and refrain from interrupting, allowing a balance of time, so checking ourselves to be able to hear from others. Be tough on the issues and questions rather than each other, so not to personalize, and then discuss topics together here rather than in isolation, as hard as that can be sometimes. Silence our cell phones. It's not as important as when we're together in a meeting room. And then as folks are, if you're able, that was lovely. If you're able to come on camera when you speak or hang out on camera, we welcome that. It's the three-dimensionality of a human mammal is certainly reassuring to me and to others, knowing that we are embodied. With that, I think those are really all the key points. Are there any questions or concern with those principles? We won't necessarily take a vote, but if anyone has a concern with any of that, or a process improvement, please let me know. Please, Nick.
Yes, just and on the last side, there was an emphasis on communications, and I just wanted to ask how we do that, how we communicate as a group between the meetings. Like, would you prefer it? Is there going to be a listserv, or would you prefer us to email information we want to share with the group to staff? Just like, what are the protocols for sort of written communication?
If you would, so the reason you're blind copied, which can be somewhat annoying, is that we don't deliberate outside of a public forum. So that's why everyone's blind copied. So if you don't mind just reaching out, if you know someone and want to find them, Google them, or ask us for contact information. Or if you'd like to share something with the RAC, please do send it to us and just let us know that you'd like to send it to the RAC. Thanks for the good question, Nick. Yeah. Most of us work for public entities, so you can find us one way or the other, but let me know if you have trouble reaching it. But okay, I seem to have frozen there a little bit. There was a little bit more about our charge. And then the timeline, just touch, I think this is actually, does this come later? Yeah. We can come back to the timeline later. I touched on it briefly, but I really would like to turn it over if I could. Do we need just a 5-minute break, folks? Running a little bit behind, but I think that's okay. Take it up on the back end. Would folks like just a few minutes of stretch break? Yeah, let's just take 5 minutes and come back at 2:15 with a few words from the Legislative Commission on Indian Services team. Thank you. Come back at 2:15. We're live. Hello, everyone. I think it's about 2:15. 2:15. I'm back. So at this point, if I could turn it over to Dr. Bullion and Director Flanagan with an overview for us on a very ginormous topic, statute and rule on archaeological resources in Oregon. Please, Melissa.
Yeah, and am I able to, we have just a few slides.
I hope you should be able to share. Please let me know if you're not.
Okay, let's see. Just have to get it to the right. Let's see. Oh, there we go. Okay. Is that, can everyone see the PowerPoint?
We did. Now we see more like a Word doc. But wait, I did see a PowerPoint.
Weird. Okay. Oh, yep. I think, hang on 1 second. It's showing me, sorry, I have too many screens going right now is what's happening. Let me kill a few of those. That will be probably more helpful. Okay, let's try this.
And Ariel did let me know that she has to step out for a meeting between 3 and 3:30. And so Ariel, good to see you now and look forward to seeing you on the other side too.
Okay, now is the PowerPoint up?
Yeah, it is. If you want to run from like the first slide or run show, we see the kind of table of contents at the left, but it works.
Okay. Well,
Up under slideshow, this is where I usually go.
All right, yeah, it's just
There you go.
Okay.
Perfect. That's great. Thank you.
Okay, I'll jump in here because I'm going to take these first few slides. And again, for those who might not have heard earlier, but just by way of review, my name is Patrick Flanagan. I'm the Executive Director, Legislative Commission on Indian Services. I will start off by saying it's good to see so many of the tribes that are represented here. And just as a reminder, although I am the Director of the Commission on Indian Services, and I've already said that we're kind of the liaison between the state and the tribes, it's good to see the tribal representation here because it's always worth remembering that the tribes speak best for themselves. The commission, although we are comprised of those 9 tribal chairs and those 4 legislators, the tribes will remind you, and I'm sure you will be reminded on many occasions during this RAC process, that there are 9 federally recognized tribes in Oregon. All of them are distinct and unique. Hearing from one tribe is hearing from one tribe and not hearing from all 9. So it's good to see so much tribal representation and participation here. And I encourage all of you to reach out to those tribal representatives with questions or concerns, as well as reaching out to us if we can be of assistance. I'm going to start off with some background here, and this is really fundamental background, but I think it's important background. Of course, for the tribal representatives, this is not going to be news to them. For many of the state agency employees, this is not news either. And frankly, for our counties, our cities, municipalities, it's not news for them either, but recognizing that not everyone that's participating in this RAC engages with tribes on a regular basis, either just as a practical matter or a statutory matter. I think it's important to think about the framework that we're coming from here. And I've already heard in the introduction some comments about absence of rules, lack of guidance, things of that nature. And I want to submit that actually we have ample guidance, whether it's specifically written for your entity, for municipalities, for counties. We have ample guidance on what that government to government relationship should look like. And if we're going to start from that perspective, we have to talk about kind of the federal perspective. And I've been using a term, I'm reluctant to use the term, but I haven't come up with a better one yet, but I talk about the trickle down theory. And I know we've especially those of us who are a little bit older, recognize that terminology, and I'm hesitant to use it, but I think that it applies here because I want to start with that federal paradigm in the relationship with tribes. And just as a reminder, Article 6 of the US Constitution says that all treaties made shall be the supreme law of the land. And so what that does is it provides us a good framework, a good understanding. One of the questions that I frequently hear, or at least indirectly encounter, people might not say it outright, but there's kind of a concern or a question of, well, how do we deal with tribes? I don't understand what these entities are, and frankly, we don't afford the tribes the level of respect or decorum or treatment that they deserve, because we fail to remember that treaties are the supreme law of the land. And treaties, although not every tribe in Oregon is referred to as a treaty tribe, every tribe in Oregon has a treaty history. Now, those histories are different. Every tribe that had a treaty, some of those treaties were never ratified. Even among the treaties that were ratified, some of those tribes were terminated and then restored. And then some tribes have retained that original treaty relationship with the federal government. Nonetheless, all of them have a treaty history. It's just that history differs. And if they have that treaty history, it's a fundamental axiom that treaties are achieved among, I will say, equals. I don't mean equals from an economic perspective or from a power paradigm, but for example, the United States would enter into a treaty with Mexico, but the United States would not enter into a treaty with a state within Mexico, right? That's just not equal parties. And so if the United States chose to enter into treaties with tribes, that, at least impliedly, if not explicitly, says that the United States was treating tribes as equals. That should inform the way we approach tribes at the state level, because if that's the way the federal government is approaching tribes, that's our first paradigm. So I start with Article 6 of the Constitution and the Supremacy Clause. Alyssa, next slide, please. So among those notions that go along with sovereignty and the treatment of tribes as equals by the federal government, tribes are unique legal entities in the United States. They're distinct political communities with extensive powers of self-government. That tribal sovereignty predates the United States. And as already stated, the Constitution considers Indian tribes as separate governments. I want to emphasize that third bullet point really quickly. A lot of people think of tribes as a creation of treaties, and that those treaties gave tribes certain things, for example, sovereignty, and that's not the case. Tribes were sovereign before those treaties were entered into. Similarly, one of the terms that's used quite a bit, but we talk about reservations, rights that were reserved, but we mistakenly, and I say we, I recognize everybody's sitting in this virtual room with a different perspective and different knowledge base, but I would say generally, it's interesting that I think in the United States that many people think of those rights that were reserved as rights that were given to the tribes, but that's contrary to the language. Those rights were reserved by the tribes. They already had those rights. It was just that they were being maintained under the treaties. So that just like those rights that were reserved, sovereignty predated the treaties. Sovereignty predated the United States. Next slide, please. I won't go through all of these bullet points. These are just some more examples of tribal sovereignty and the relationship that tribes have with the United States, with the federal government. And that last bullet point is one that I've already mentioned, that not all tribes have that treaty history, but those histories vary. Next slide, please. I do also want to say, I think it's an important time, and without trying to step into a hornet's nest or create any problems. I know, it was mentioned during introductions that this process is not just about the tribes, and that the tribes were approached, and that this topic was discussed, and the tribes recognized that there are other entities and other groups that have an interest in the outcome of this RAC, and that it's not just about tribes. And while I would agree with that and endorse that 100%, I do think that it is important to remember the unique status of tribes as governments. And while it might not be all about tribes, the tribes are participating in this automatically coming from a different paradigm, a different perspective, right? Because the tribes are the only ones that have that legal relationship with the federal government among all of those interest groups. That's not said to diminish the importance of any of those other groups. It's only to emphasize that treaty relationship that exists and that government to government relationship that exists with tribes. I think that's something that will be important to remember throughout. And I think there's two ways in which this RAC will engage with tribes. One of them is kind of at the 30,000 foot level, where it will be government to government. DLCD is obligated by statute to engage in consultation with tribes. And so the product of this RAC will be subject to consultation with the tribes in that consultation process. But then also on a micro level, what is contained within the rules will directly impact tribes. And so there's kind of two different levels of interaction with tribes that's going to exist and derive from this process. And so I think it's important to discuss this tribal history for both of those reasons and the way this RAC will engage with and consider tribes. So we already talked about that federal paradigm. The state has a similar process, right? The state does not have the same specificity as the feds have, as we see at the federal government level. But the state also has obligations towards the tribes that are unique obligations towards the tribes that come in the form of a government to government relationship. Specifically, ORS 182-164 and the related statutes direct state agencies to develop and implement a policy that promotes communication between agencies and tribes, identify programs that affect tribes, coordinate with tribes in the implementation of agency programs. That last bullet point, which is actually 182-164 sub 3, coordinate with tribes, that's the section that we always reference when we talk about consultation. It's recognized that the word consultation is never used in the state statutes, but this coordination with tribes in the implementation of agency programs, that's the language that closely mimics language that we find at the federal level that requires consultation. And so that's the section that we always rely upon. I will note too, and it'll probably come up in conversation here throughout the course of the RAC, you'll hear reference to cluster groups. And so those of you who aren't familiar with them, Senate Bill 770, which became ORS 182-164, also kind of helped foster the development of these cluster groups. They're subject matter specific work groups. There's a cultural resources cluster. There's a natural resources work group. There's the education cluster, public safety cluster. But these subject matter specific work groups exist and are comprised of tribal representatives, tribal participation, and state agency personnel whose agencies touch those subject matter areas. And they're really what we think of as that coordination as opposed to consultation. It's not government to government interaction, but it's where that day in and day out coordination between state and tribes works. And so you may hear reference to these cluster groups. That's what those groups are. And they are part of and help facilitate that formal government to government relationship. Next slide. So this is the statute that I was just talking about. I'm not going to read through this point by point, but here is the point that I want to make. And this also kind of talks about that trickle-down theory from the federal government to the state, and then what at least theoretically exists for guidance for municipalities, counties, cities, entities of that nature. So 182-164 talks about that government to government relationship. And what I want to point out is point sub 3 there talks a state agency shall make a reasonable effort. We just talked about that in the consultation, coordination versus consultation, but I highlighted the term state agency for a reason. Next slide. So if you then go to the definitions, state agency, and I love how we do this, right? We couldn't just define state agency there in 182-162, the definitions. We had to then send everybody to a different statutory section, 358-635 for the definition of state agency. But when you go to 358-635, state agency includes all officers, employees, agencies, boards, committees, and commissions of the legislative, executive, administrative, and judicial branches of state government. In other words, one of the things we run into is, well, this is an obligation of state agencies. State agencies are required to engage in consultation, but I'm not a state agency. And one of my responses to that is, well, state agency is far more broad than many people realize. Because if you look at the definition, state agency goes beyond that traditional notion and includes all officers, employees, agencies, boards, committees, and commissions of the legislative, executive, administrative, and judicial branches. Pretty much everybody in the state is subject to these statutes that talk about the obligation towards tribes on a government to government basis. So here's what I would submit to you. And I think that might be my last slide, although I'm not positive. Oh, no, I think the LCIS slide is coming up. So what I would submit to you is, although we don't have specific references in many instances for how counties are supposed to engage with tribes, how cities are supposed to engage with tribes, how municipalities are supposed to engage with tribes, what we do have is we have a very well laid out model from the federal government. We have both that constitutional directive, the supremacy clause, and then what I am going to show on the next slide is some guidance on how consultation should look, how it should happen. We also have state definitions and statutory requirements and very, very broad requirements. And there's in other words, there's a lot of information out there as to perhaps how other entities other than the federal government or the state government should approach tribes and interact with tribes. It's ample guidance and direction. While arguably it may not be mandated of other entities, one would be left to wonder why, perhaps, if this is the model that exists, and knowing that this is what tribes will expect, because this is the tribal experience with the federal government, and this is the tribal experience with the state government, it's reasonable that the tribes would assume that they would get that type of approach or interaction from any level of government, and the model exists. So go ahead and go to the next slide. If anyone wants, we can certainly provide it. Otherwise, people can just look it up very, very simply. This consultation memorandum on uniform standards for tribal consultation comes from the executive branch. It's an executive directive, a memorandum from the Biden administration, November 30, 2022. And it is a very detailed memo that gives guidance on what consultation should look like, when it should happen, how it should happen. It doesn't take much to pull from this document principles that would apply at the state level, and then arguably principles that would apply at any other level of government as well. This memorandum references earlier memoranda and executive orders, but there is plenty of guidance or direction that exists. Next slide. And I just wanted to toss this up there because in light of all of this information, some fairly heavy legal concepts, some maybe new concepts or new ways of thinking about the interaction between various governmental entities and tribes. If nothing else, know this. As I've already stated, the Commission on Indian Services is a liaison between the state and tribes. But the services that we offer can be far more broad than that, the assistance that we can offer. And this is simply a screenshot of our website. We have a lot of information that's available on there under LCIS resources. There is educational information and material. Also under About LCIS, you could see information specific to permits and cultural resources. There's a drop-down tab there. And equally important, on the 9 Tribes of Oregon tab, that's a drop down. And if you were to hover over that tab, there would be a link for each of the 9 federally recognized tribes of Oregon. And when you click on that, it takes you to a page within our website that has been provided by and endorsed by each of the 9 federally recognized tribes of Oregon that talks about the tribes specifically. Has information that they want to have conveyed within our website that talks about their history. Also has a link to their specific tribal website where you can find all kinds of information about that specific tribe. And then there will be a right-hand column on the screen right now. For the homepage, it says announcement and FAQs. But for each tribe, that right-hand column is actually a list of contact points for the tribe, as provided by the tribe. It will provide you with information as to who the tribal chair is. It frequently will provide you with information as to who each of the tribal council members are. Many of the tribes elect to provide information about who their natural resources staff are, their cultural resources staff, as well as contact information for them as well. So I understand that perhaps what I've presented so far has brought up a number of questions. Happy to address those within the context of this discussion, whether it be now or after Alyssa and John have done their presentations. Also happy to address any of those questions offline through direct contact to our office, and happy to try to be of assistance in any way that we can. So I think that kind of concludes the 30,000-foot overview of state tribal relations. I think we managed maybe to address state tribal relations within 15 minutes or so. Obviously, we can't do it justice in that amount of time. There's a lot more to talk about, but I wanted to at least give a brief overview here.
Director, thank you so much. This is just Kirsten popping in as a transition to Alyssa. Thank you. And if we could share these slides out, Commissioner Thompson also asked that we share out that uniform code, the direction from the Biden administration as well as a sort of a PDF in the packet as well. But this is very instructive. Like I said, we sadly not taught in schools, certainly not schools of planning, unfortunately, yet. But Alyssa and I are on a mission on that as well. So a mission in a good way. Please, Dr. Bullion.
So I'm actually going to have John go next, just because I think the kind of logical order makes a little bit more sense. So I'm going to kick it over to John, who has, I think, just one slide.
Thank you. Thanks, John.
Yeah, thanks again, everybody. John Pauley, state archaeologist at the State Historic Preservation Office, also known as SHPO. And these are, so I pretty much live in the world of state and federal laws every day. And these are the Oregon revised statutes, and there's one associated Oregon administrative rule that I work with. Some of these I work with every day, some of them it's on occasion. And ones that are on occasion, sometimes that's a good thing. In particular, the first statute, ORS 97, 740 to 760, which addresses Indian graves and protected objects. The statute defines, or it first identifies that, it's a Class C felony to damage Native American graves, funerary objects, sacred objects, objects of cultural patrimony. This is a statute that is, and all of these, for that matter, are, 40 plus years old. So it's an old statute. It does not have a rule for it. So some of the things that are in the statute kind of leave us wondering what actually was meant by it. I know that there's a different process for updating statute than there is for rules, but sometimes I wonder if one or the other wouldn't be helpful for this and other statutes. But we're named in here in a weird sort of way, because it's a statement that says something to the effect of, if a professional archaeologist wants to excavate a burial or a cairn or something like that, they've got to contact SHPO, and they also have to have written approval from the appropriate tribes. Doesn't really say why they have to contact us, but the way that I interpret this is because our office issues permits for excavation and collection, that it's probably because of that reason. And we were talking earlier about, cultural sensitivity and things like that. In some ways, there's a little bit of cultural insensitivity here, because the permits we issue are for archaeological objects, and those do define burials, Native American burials in that regard. But as I was kind of mentioning earlier about things, it's about people, and these were people, and their ancestors are here with us today. And it seems a little bit weird, but it also is a way to separate folks that are doing this horrific thing, maliciously, versus when there is a need. And it's rare, but it does happen. And when that does happen, we absolutely have the tribe's approval and all of that. There's no way that our office would issue a permit without the tribe's approval when it's gotten to that point where all other options have been exhausted and there needs to be a recovery. And so that's that statute. And I know Alyssa's going to be talking more about it. So I just wanted to mention a little bit of our role in that one. Patrick mentioned 182 earlier, and I just wanted to say that, so for SHPO, it's a little bit weird because we are housed in OPRD, and OPRD has their policy statement.
John, do you mind just mentioning Oregon, what OPRD is?
You bet. Oregon Parks and Recreation Department. So that's where the SHPO lives right now. Originally, I think we were in Department of Transportation a few decades ago. But so OPRD has its policy, which is mostly about dealing with tribes through parks operations and things like that. But for the SHPO, when I've seen it used in the past is we are oftentimes a required signatory to programmatic agreements with federal agencies or memorandum of agreements with federal agencies. Programmatic agreements oftentimes are the intent of those is to streamline a federal process, the National Historic Preservation Act, and specifically Section 106 of that. And at times tribes have, asked us to pump the brakes on signing a programmatic agreement because they believe that by signing it, there would be effects to them in places that are considered important because things may not have been considered or, in the details of that. So that's one way where I'm directly involved with that statute. And then the next one is exemptions from public disclosure. And in that part, 11 of that, it just says the location of archaeological sites is exempt from public disclosure. That's one where I guess if I'm going to give just my personal opinion, but I wish that it addressed more than archaeological sites, because there are in the federal law, there's exemptions for different types of places that are important to people where there could be harm to the place itself, regardless of if there's objects and stuff. But in Oregon, ours is just addressing archaeological objects and sites. And so we're not allowed to disclose the location of those unless they're very, common, publicly known, which is I couldn't even think of one of those off the top of my head, but so oftentimes we do get records requests, and then we have to make sure that we're not sending information that would allow somebody to find an archaeological site. Archaeological objects and sites are defined in the next statute in 358905. And so that's kind of a interesting statute because it's on the federal side, it's the age requirement is 50 years, depending on which law we're using. 50 years for the National Historic Preservation Act. If we're looking at the Archaeological Resources Protection Act, it's 100 years for archaeological sites, and Oregon, I guess, split the difference, and archaeological objects and sites have to at least be 75 years old. There's all kinds of nuances in this that I won't bore everybody with that we have to deal with, but this law basically says that a person may not excavate, injure, alter, or destroy an archaeological site or collect an archaeological object without first obtaining a permit from SHPO. I think the statute actually says from state parks, and because we're in state parks, they've they've delegated that role to us. So we issue all the collection, excavation and collection permits throughout the state, and that are on non-federal public lands and private lands. Those permits, according to that the next statute, 390235, the permits and conditions for archaeological excavation, those permits may not be issued without the approval of tribes, the land managing agency, and our office. So that's an important thing. Tribes have a huge role in that, in the issuance of permits for that very reason. And the administrative rule originally was drafted in 1994, and it was quite out of date. And the associated statute mentions that we're to develop rules for that statute with the advice from the tribes and the Legislative Commission on Indian Services. So we went through that whole process beginning in summer of 2021, and then we also had a RAC that I think some folks on this RAC were on, and our new rules were approved in November of 2022, and they became effective on July 1st of 23. And so there's a lot of updated information in that rule regarding the governing the issuance of archaeological permits. And I know I hope everybody's still awake after talking about statutes for this much, but if folks do have questions, I'd be happy to answer them at the end. So thank you.
Thank you, John. Really appreciate it. There's a world and many worlds and so much depth in there, what you just went over. Thank you for being here to help us sort of navigate our understanding and learn together. For those that aren't intimately familiar, about half our committee probably is. If Alyssa, would you like to pick up here? Did you have a few slides?
I do, yep. And so thanks to Patrick and John for giving us kind of a couple of different scales of state tribal interactions and kind of what's going on the state side for archaeological rules and statutes. I'll try and keep my comments briefish because I want to make sure we have time for questions and all that. But I want to take us a little bit from the land of kind of rules and regulations into just a few kind of more concrete, maybe practical resources. Again, just to give folks a background idea and understanding of what we're doing on the state side. And I'm mostly going to be focusing on archaeological sites, objects, as well as ancestral human remains and burials. So full acknowledgement that that is just a subset of the resources that this RAC is seeking to address, obviously. But I just wanted to take a few minutes to give some examples of some of the resources that the state has already developed that could be useful on the kind of municipal, city, county level. Some of these resources are things that I know local governments are already using. Some of them might be new to some folks. And there's also several people on this call who've been integral to development of these resources and are honestly much more knowledgeable about some of the development of some of these resources than I am. So first of all, yeah, kudos to those individuals. And I will just say that if any of them find me saying misinformation about any of these resources, they're free to jump in and interrupt me. So when we're talking about cultural resources and projects and the protection of these resources, both archaeological and more broadly cultural, the protection of that obviously starts way before any work is actually happening on the ground, way before anyone puts a shovel in the ground or anything else. But and as a part of that kind of early development project planning, something that needs to be anticipated and thought about is, you know, what happens if even if due diligence is done, you know, speaking with SHPO, doing archaeological surveys, speaking far in advance with tribes and other cultural communities. What if, despite all of these things, there's still a cultural resource that gets disturbed, uncovered, etc., by a project during its actual undertaking? The good news is that you can actually help prepare for these situations to help mitigate any kind of damage or harm that might come from that kind of a situation. And that's by having something called an inadvertent discovery plan. And again, I know that there are certain cities and municipalities that already have these plans. I know Salem already has one of these. In effect, I've seen a few others come across my desk with folks just asking me to help look at them or develop them. But the great thing about these plans is, again, it's really a chance for you to look at what a project, where a project's going to be, what it's going to entail. And even if, again, you've done your due diligence, this is not a substitute for doing all of that due diligence, but it's kind of a worst case scenario. This will help you understand what to do in the moment, help your personnel at whatever level make sure that they're contacting the correct experts and people who need to be involved. And these are things that we have templates that have been developed on the state level in consultation and coordination with tribes and state agencies that can be really honed in and adjusted for specific projects, but you don't have to start from square one necessarily. So that's kind of the good news, is these resources do exist as a starting point. And I would encourage everyone to look into developing a template for your region if you haven't already thought about this. So what are actually in these plans? It's really, again, a guidance document for what happens and gives specific kind of tailored guidance depending on the type of resource that may have been encountered, with the biggest distinction really being between archaeological sites and objects and human remains and burials and funerary objects. So there's two different processes and steps and guidance depending on the type of potential resource that is encountered. And so these documents help understand what needs to be done in the moment, including, you know, what kind, the area that within which work needs to be stopped, for how long, guidance in terms of, again, if there's any specific treatment recommendations. So, for example, with human remains, there's guidance about the fact that, you know, no further, you know, disturbance or touching of the remains should happen after that discovery of potential remains. And potentially the most important part of these documents, I would argue, is having an updated notification list of all of the folks from the project side of things, on the state side of things, the tribal side of things, who need to be contacted and made aware of this discovery. And so a lot of folks, I think, are you know, concerned that they don't know all the different things to do if something like this happens. That's what this list will do, is it helps you then bring in the expertise and that additional knowledge and guidance of all these additional individuals and resources. So again, needs to be tailored for specific governments and projects, but these can be really strong documents and resources for folks. And again, they're implemented at the state level and in certain municipalities, and I would really encourage pretty much anyone doing a project to have one of these. And again, thankfully, you don't have to reinvent the wheel. Just a few comments on my own position, since in my position, I guess you could consider me a resource for state as well as local governments in some of these cultural resource and human remains and burials encounters. Ideally, you will never have to call me, but if there are concerns about burials being found or potentially being in an area, I am a resource. My position focuses on what are known as non-modern, non-forensic human remains. So not kind of modern criminal cases. And, you know, native and non-native ancestral remains are within my purview, as well as, again, those burials, funerary objects, and those additional special contexts. So a lot of my work kind of falls under the one of the statutes that John mentioned, this ORS 97745, and my position does also appear in the SHPO permit OARs as well. And yeah, in my position, I work currently really closely with tribes and tribal representatives, the Oregon State Police, and medical examiner's office. And this is also another kind of interesting place and something I'd like to point out just at the nexus of the kind of municipal and local county governments, because a lot of times there's a question when local law enforcement and medical examiners need to be involved versus on the state level. And for these fines, it's really a state level investigation, intervention that happens. So while, say, local law enforcement might be initially called, it's something that Oregon State Police and state medical examiners have the expertise in consultation with myself, SHPO, and the tribes to take care of these cases. So that's one place where I'm really trying to do more outreach to local counties and governments to really help spread that understanding that it really needs to go from those local resources into the state system to make sure we're making those connections with folks who really understand how to handle these sorts of situations, and that we're doing all of this in a very timely manner, because it's important that folks are made aware of these situations as soon as possible so that we can make sure that ancestors are protected and treated the way that they really need to be. So just really, really briefly, I want to bring up a couple of other resources that state agencies in coordination with tribes and tribal representatives have created throughout the years to just as things that you might be interested in either replicating or taking advantage of, again, so you don't have to reinvent the wheel at the state or at the, city and county level. So this is kind of an older pamphlet that hopefully we might be able to update soon, but still a really good, solid informational packet, very accessible, kind of broadly. It talks about kind of different types of cultural resources, what are illegal activities, and kind of what to do if you might see illegal activity. So just having something even like this can help develop that really basic understanding. Not everybody has to be an expert in cultural resources, but having some of this information so that folks know how to react in these cases can be really helpful and powerful. And then if we want to get a little bit more into the weeds and folks are interested in learning about more specific cultural resources, a lot of the state agencies and tribes have also developed really robust trainings and educational resources to help you understand. So I pulled out some of these about culturally modified trees, in part because they're fantastic resources that ODOT in collaboration with federal agencies and tribes produce. There's kind of both a PDF pamphlet as well as a really fantastic training that's on YouTube. Again, really accessible and just something that if folks are interested in finding out more about specific types of resources that might be especially regionally significant. Again, there are a lot of these fantastic resources that the state has created and that are for a large part also available more broadly as well. So that's the end of my presentation. Again, just kind of wanted to bring things back to a little bit more concrete level and thinking about the kinds of things that the state already has produced and might either be able to be incorporated or inspire some of the conversations and just thinking about meeting the needs of the local and municipal governments. So with that, I'm going to stop sharing and hopefully we still have time for questions.
Yes, let's John, Patrick, thank you very much for that. Again, a world of overview in really just a few moments. So that's sort of a tip of the iceberg, if you will, to mammoth sort of suite of knowledge, existing law. So none of that is what we're working on. That is all existing background. And also just reminding us that those are, we're talking about folks' ancestors, so these are not isolated objects that we're talking about. It's living people's family members. So thank you. Any questions or comments from RAC members? There will be no test. That was a lot.
If I may,
Please, Councilor, yes.
and I failed to say this in my beginning, but I had been in a Culture and Heritage Department for some time, off and on, and I made a transition into the Planning Department. And working with Melissa before her coming on was just was a great opportunity for us to actually engage a little bit more with the local officials, so to speak, in two different counties. But just having Alyssa on really gives shed a light on that somewhat dim area before, but the Inadvertent Discovery Plan and how that's been basically how it went from pretty much I wouldn't say nothing, but to what it is today is, and her work has been outstanding. I just applaud her for that, and the legislation or everyone, whoever is involved in bringing her on.
Yeah,
Thank you.
The Oregon Legislature and LCI's advocacy. To hear from the state, thank you, Councilor. To hear from the state archaeologists and anthropologists, we are very fortunate. So, thank you both. Alyssa, is that draft IDP? I know I've been carrying around a copy with me for a couple of weeks now in my bag. Is that something we could circulate to Rules Advisory Committee members if we put draft all over it?
I think so. Yes, okay. I'm still waiting to hear back from a few folks and making sure that everything is that we have all of the input before kind of sending it out into the world. But yeah, as kind of a draft form, I think that would be acceptable. Honestly, most of my tribal partners who've helped me develop a lot of it are on here now. So if there are any objections to that, this would actually probably be a great forum. I'm welcome to obviously hear that input. And I see Bree's hand up as well. But I also just briefly wanted to thank Les for his kind words, and also just point out that it was largely the efforts of the tribes that really got my position created and funded. So really they're the ones who deserve the most credit in the creation of this. But yeah, with that, I'll kick it over to Brees.
Thank
you. Yeah, thank you for that. I'm going to be really brief. I just wanted to think in the thick of all of this that one point I'd like to highlight about that Inadvertent Discovery Plan is that it is applicable to all cultural resource. It is not specific to one cultural affiliation, nor one temporal period, nor ancestral remains. It is actually designed to be a tool to walk the inexperienced through a process of start to finish. And I think that's speaks to kind of what we're talking about here, what we have in front of us as a charge. So I just, Alyssa, I didn't want that to get lost in everybody's comments. So thank you.
Yeah, thank you for pointing that out. That's true. And that's one of the strengths of the IDP is, again, it doesn't have to be this narrowly applied document. It may kind of come across that way, but yes, it can be. It's not just about tribal heritage, it's not about archaeology. It's not just even about historic resources. It can be very broadly applied. Absolutely. So thank you for pointing that out, Brees.
I was frankly I still can't believe the lightweightness of it. I'm not sure if you've made it any longer, but this is approachable and accessible, Alyssa, so thank you. And it has a really important kind of flow chart at the back. So it's elegant. and easily demystified. So thank you. Even a planner should probably use it. Sorry, planner friends. But you don't have to be an expert to use it and to basically, follow the steps there if something unexpected were to happen in terms of the development process. And I think that's exactly the type of resource that some of the smaller local governments too, that Ariel was mentioning too, would look for this type of model to be able to have at their counter. So thank you for your work developing that.
Yeah, absolutely. And again, definitely a group effort. I'm mostly just wrangling folks to get all their good ideas in one room. So, but I'm glad that that even a non-archaeologist can look at it, and that it seems that it's approachable and really clear, because that's the goal, is to get everyone on the same page.
Mm-hmm. Fantastic. Well done. And certainly we could put a date draft on. I noticed that the copy I have printed does say draft, but we could put a date draft on it just because I know it probably will continue to evolve, but amazing. So thank you. If I could turn over to Amanda, we are going to start to dive into content. So this would be the first part of the rule. We talked about starting with definition, and we're starting. So I want to thank everyone for the sharing to date, important kind of level setting. And without further ado, if I could turn it over to you, Amanda, to introduce this preliminary draft definition.
Certainly. So I want to preface this with what we know, that culture is everywhere, right? We all have a culture. We all have things that are important to us culturally. And as mentioned earlier in this meeting, that historic resources are cultural resources. Tribes have often reminded us or said that in tribal culture, natural resources are cultural resources. So in that very broad world of what are cultural resources, we'll need to figure out how we want to confine, maybe, or draw some parameters around what this Goal 5 rule is going to address. Now, when we talk about the category, like even the somewhat truncated category that we might end up with when we have a definition of cultural areas for this Goal 5 rule, that is the larger bucket from which for which things that meet the definition might require more scrutiny, more assessment. So at least with other Goal 5 rules, what we tend to have is we have a definition of what the resource category is, and then we have either process or thresholds, possibly another more refined definition, or a combination of all those three that get you to what we refer to as locally significant resource sites. And it is locally significant resource sites that local governments then have some obligation to do more, to either protect or do more assessment or things like that. So while the conversation about what the definition of cultural areas is going to be for the rule won't be the end of it, right? So after we do that, when we get into an actual draft rule, we'll be talking about how to then narrow that to where significant cultural areas that will require some kind of further assessment / discussion / protection when local governments are doing planning, whether that be issuing a permit possibly, or expanding an urban growth boundary possibly, or applying urban zoning in an area that does not have that already. Those are different levels of planning activities, but and so right. So I think I'll just stop there. And so Am I right? In the packet, there was the other discussion, the other examples of cultural resource definitions, right?
Yes, yes, correct.
So really, I think this is just we put the straw man definition up. Well, Kirsten felt it was a good one to start with because it actually came out of a narrative that had been shared with our commission, the Land Conservation Development Commission. Once we have a definition, we have to think about exactly how it's worded. This is kind of more just a general thing to start with. So like a detail, like cultural areas are these things, we say include these things. I think so I'm going to stop talking, and because I think this is a time for people around the table to share their thoughts about how to approach a rule. How to approach a definition for this rule.
Great, Amanda, thank you. Kimberly has your hand up. Thanks, Kimberly. And then perhaps Nicholas. Nick and Nicholas, you'll have to tell me which you prefer, sir. Probably Nicholas, since it says, okay, interchangeable. Thank you. Kimberly with an I, please.
Thank you. I think I'm probably going to put John on the spot. I am curious whether there are existing definitions within existing rules that apply that we could reference here. I do appreciate the examples from the other locations, but I'm very interested in Oregon revised, the rules in Oregon, whether there's anything we could pull from there.
I'm going to say no, because even if there are discussions or descriptions of what cultural resources are, there's not, cultural areas, like maybe those terms are interchangeable. But we don't have other examples of the of the kind of rule we have, right? So if you have got federal definitions, you have state definitions that apply different kinds of laws, then the examples that are in the packet are ones that I have found, and there's certainly a lot more out there, but we don't have a simple one in statute that I have been able to point to. And I think John Pauly might want to weigh in here, because I have talked with the SHPO staff too, and I just think we don't have something like this in rule or statute right now.
Yeah, we don't. Go ahead, Kimberly. I'll let you.
Oh, sorry. There's a second part to this, is again, with the idea of not wanting to reinvent the wheel and to be consistent across different applicable rules that apply to this. And I don't know if it's appropriate. I'm not a lawyer. There are at least two lawyers on the call. Whether to reference the specific definition of an archaeological site, and if that definition includes a reference to cultural areas or not. So I understand there's no definition of cultural areas, but just wondering, and I'll stop talking.
Yeah, no, it's interesting because in the statute that defines an archaeological site, it talks about archaeological sites of significance, which are ones that have been determined eligible to the National Register, which is a federal process. And I'll try and use a common example. There's national parks on National Park Service land in Oregon. They've got the Fort Clatsop, where Lewis and Clark camped for the winter. I think that archaeologists over the last 70 years have excavated about 10 football fields trying to find one thing associated with Lewis and Clark, and they never have. But that's listed, it was listed on the National Register, and now it's a National Historic Landmark, which is the highest honor a place can get. So I'm only mentioning that because that shows some of the frustrations that we have where, if we're dealing with a federal process, you can get places, whether there's any physical remnant of anything there, but that are just important to a community, acknowledged as such, all day long. We don't have that for our archaeological statutes. There's one that's kind of close with the administrative rule for the Department of Energy's Energy Facility Siting Council, because they use historical, cultural, and archaeological as considerations before they cite a solar project. And what's interesting is the historical and cultural part have not been defined, so it's kind of left for us to kind of figure that out. But I've always used that as like a little wedge to work something like this in for those energy projects. But I would also point out, I think Patrick either said it during his presentation or he said it during a meeting that he and Alyssa and I had when we were preparing for our presentations. But one of the things that with being more culturally sensitive and more respectful to other cultures and all of that is just kind of, for lack of a better term, being willing to do the right thing and to engage with neighbors about things. So I don't know, like, if we can point to a statute, but and maybe this is a pipe dream, but maybe we could just point to, being neighborly. I don't know.
John, thank you. Nick, and then Reese, and then Councilor Anderson, please, Nick.
Yes, some of what I was going to bring up has actually was just discussed. But just a point of a clarification, John, archaeological site is defined in statute, right? So if just, sake of argument, if this definition was adopted, archaeological site in this instance would have the same meaning as it does under the statute. That's a question.
Yeah, the archaeological site is defined. First, it defines archaeological objects. And then it basically says that an archaeological site is made up of archaeological objects. But
okay.
They are defined.
Okay. I guess the second part of my point was, and I think, Amanda, you were starting to go there about how this is a first definition, and then through a local process or other process, there'll be further definition. But what I'm raising here is that in this definition, there's no, for lack of a better term, there's no reference to an authority, right? There's no reference to significance as determined by, there's no reference to, the National Register or a permitting process or a tribal process. And that might be fine. Or an ESEE process that determines something, and that might be fine, and we might purposely want to do that. But I just wanted to bring that up because it's maybe so vague as to not quite yet be helpful. I don't know.
Yeah, thanks, Nick. And that's what I was trying to get to before. So thanks for just describing it again, where this definition probably won't do a lot of work aside from help people coming into the rule or people seeing the rulemaking process to understand that we are not talking about historic resources, let's say, or although the straw man definition we have here doesn't really do that, because it has places and sites, and historic buildings can be sites. So yeah, it's the beginning of a conversation, just the very beginning of a conversation, and then the other work will happen later in the rule. So I'll give an example. Riparian areas. Every single stream has the stream and the land next to it is a riparian area. But in the Goal 5 rule, whether through a standard process or through using the safe harbor definition of a significant riparian area, what is a riparian area is a much smaller set than all riparian areas. And then similarly for wetlands, we have lots of different wetlands. Only a subset of wetlands are assessed to have higher function and are thus determined to be significant wetlands.
Thank you. So Nicholas, stay tuned. Great question. Thanks for saying what many others may have been thinking is how to do. So that's what we're here to figure all that out. Mr. Edwards, please.
Yep, thank you. Let me put my hand down. Yeah, I really appreciated that question about who's the definer of this. And to that, I would point people to page 1010 of the packet, and the tribal cultural landscape definition, which does call out in that example, because it's specific to tribes, that descendant communities speak for themselves about what area is important to them and how, in what way that place is important. So I think that kind of steps into what you were bringing up about who is the authority to speak for whom when we're talking about cultural areas. That could be a possibility. I think that it's important that area makes reference to a place. Culture is defined by communities of people, and who are closest to those cultural elements for which an area has value or significance. That may be multiple communities with connection to the same area with overlapping priorities, but this is an approach this way that does not add a weight of one having greater precedent than another. And I think that's something to make sure could be captured as we're looking at a definition, that it's not a one voice speaking over another when it comes to identifying. It may be a different issue down the line with what those next steps look like, but it shouldn't necessarily be at risk for identification. And that was something that I found a positive in that BOEM definition. So I just wanted to bring that up and think that it helps us meet that point that you brought up.
Thank you for that one. It's just highlighting it on this screen for those that don't have sort of a hard copy next to them, but that you should have that electronically, and anyone that's viewing via YouTube or listens to this later, it is on the packet on the website. But Reese, thank you for that. I know that also represents years of work. Councilor Anderson.
Kirsten, could you please bump up the size? You're at 48%. Put it up to.
Yeah. Can anyone actually read that? Is another matter. Councilor, go ahead, please.
Let me see. No, I can only ditto what Reese just said. I was looking at that as well. And, we're thinking back about these definitions, of course, when these definitions were being laid out and things, there probably wasn't a whole lot of tribal input in defining these definitions. It was somebody defining us, who we are as a people, and our remnants of what our ancestors has left behind, and we as we use those today. I can say for our county here, just looking at it, of course, with our dam removal in the process of now, our environment is changing. So these definitions also have to change along with this environmental that's happening as we speak, that will take us into the next millennium of things. So that's exactly everything he had mentioned there. The landscape is more of where I was going to kind of talk about a little bit of a cultural landscape is not so much defining, from 2 flags to 10 flags to, so many square feet and, so much material and blah, 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 blah. It gets too much into a science. And when we're looking at this as tribal people, well, we're looking at an environment and our culture. And so, how do we take those definitions and apply what we've been doing for millenniums to that and putting us in a box, so to speak, or our traditions in a box. So no, I the National Park Service, I believe that's the National Park Service, correct? Yes. On page 10.
That was actually from Brees. Go ahead, Brees. Do you want to mention yours on page 10? They're the bone.
Yeah. Sorry, Les, go ahead.
Well, I was looking at the bottom of page 9 and top of page 10 when you were that's what I was looking at. But no, that's my comment. Thank you.
Thank you, sir. Yeah, the counselor, right below the National Park Service was the U.S. Bureau of Ocean Energy Management, a guidance document for characterizing tribal cultural landscapes. And Brees, could you describe kind of the group that developed that definition? Thank you.
Sure. I apologize, Dave. I saw your hand up there, but yeah. So Bureau of Ocean Energy Management, now almost 10 years ago, there was a call for developing a concept about how does one identify a tribal cultural landscape, large areas that are culturally identified. To Les's point, where the unit of operation is how and where you exhibit your practices as a coalesced community, whether that's huckleberry picking, for instance, or where you go to fish or hunt or have ceremony. Those are just examples. So as part of that project, that undertaking in transparency, Confederated Tribes of Grand Ronde partnered with the Makah tribe and the Yurok tribes and came forward in workshop this definition to try and address some of the adjacent issues that the Goal 5 is looking to address here. This definition is the outcome of that workshopping and then vetting through, I think the total was 50 plus tribes and bands from Oregon, Washington, and California. And this was the outcome. So it is adjacent to what we're looking at here in Goal 5 charge, but I do think that it has some of the elements that, and as part of developing this, we wanted to address area and allow the voice of the people who have the knowledge of it. And that does make reference back to some federal laws and statutes, but is equally applicable to, immigrant communities that have lived here, who have been forced to move here, who have in their own ways created an identity of place. I'm going to point to Basque communities of shepherds in the 1880s who have left their mark and identify home here. This, if you were to swap out tribal cultural landscapes, you could just have strike tribal and you could have cultural landscapes determined by and known to culturally related group of strike indigenous people with a relationship to the place. So the key variables being people, place, and practice. Some of you have heard me say this before. People and place give us our nouns. Practice gives us our verbs. And we are required to have both to write a complete sentence. So this definition embodies that element here. So feel like I'm beginning to overtalk that. So
at all. It's very important. Brees, thank you. You may be very familiar with that definition, but the rest of us are newbies. So thank you very much. Mr. Honeycutt, please. Yeah.
Thank you. Looking at this from a regulatory lens, because if this is going into Goal 5, it's going to result in having regulatory impacts. I'm a little nervous with the word include. If all these things are included in the definition, then what else is included that we don't know about? If we're going, if we're going to use that word, we need to flesh out everything else that is going to be included so that we have so that the regulated community has an idea of exactly what it is that they may be subject to as far as areas that are subject to the regulations. If we archaeological site, I just looked up the definition. I'm sure there are multiple definitions, but I looked up the definition, and this one I think is on the American Society of Archaeologists, or one of the trade association, or one of the educational associations for archaeologists, and the definition is essentially any place where there are physical remains of past human activities. Well, that's also significantly broad. I would prefer not to start from essentially everything and work our way backwards. And so archaeological sites, I suspect, would probably need a fair amount of tweaking, and maybe a statutory reference. We did talk about a statutory definition. If we're going to use a statutory definition, however, I would suggest that you refer to that statute in the actual definition as well. And the only other thing that strikes me just right off the bat from this, we talk about culturally specific communities, and I don't exactly know what a culturally specific community is. I certainly understand and appreciate the interests of the tribes and don't want to diminish that in any way whatsoever. But apparently, if there are other culturally specific communities, maybe we ought to discuss, what those communities are, so we get a better idea of the breadth of the potential scope of this regulation.
Okay, thank you. 3 good points. Appreciate those. And we will have, I think, the easiest of that, they would be to include the statutory reference. So I think that would be a good and easy-ish add. Insert John and Alyssa's slides in the appropriate reference. Whether or not to include, and then for the defining culturally specific communities, I think we can continue to just sort of consider and work out together in our work. Does anyone else have a question or comment on this point? We will include this, like I said, we can transition to some of the next steps, but honestly, the discussion is, we won't need this whole half hour for kind of schedule the next step. So if anyone else has anything they'd like to discuss, please be welcome. This with amendments, thanks Ed, just one sec. This with any amendments we just discussed today, Amanda will include in the draft rule in your packets for the second packet. So you'll see this with any amendments today, and it's kind of nested in the entirety of a draft rule, which I know too that we'll want to be doing some extra outreach on that. Ariel called for a principle of no surprises with local governments. We certainly agree. It's our agency's responsibility to be in partnership with local governments as well as tribal nations. So we're working at that outreach as well of the periods of sort of RAC 2 and 3, trying to do specific outreach in fora to which greater community can participate directly. Mr. Sullivan, please.
Yeah, I take Dave's point on the includes part. And I guess I started off with looking at the historic resources portion of the Goal 5 rule, and that's 660.23, 200, sub 1E and F. It doesn't use includes. It does have specific things in there, but I think you got to look at this in context. What we're looking at is the front end of the whole process. What might be included, all right? And there's a lot of discretionary choices made thereafter. Do we have enough information? Is the site significant? And for our tribal friends, if you want to have something included, this is more difficult if you leave it open-ended, where a local government can decide that we're going to take it out of the running. we don't have enough information, we don't think it's significant. So it might behoove us to have a little more in the way of detail here, rather than to make it open to the entire world. Exclusion by the local government is relatively easy, and while not immune from appeal, it's pretty difficult to overcome a determination that there's not enough information or that this is not significant. So just to build that into the definition part.
Thank you. And Commissioner Thompson has her virtual hand up. Commissioner, please.
Well, and here's the thing. I don't want to take us off on a tangent or spoil this really lovely process. I always apply what I hear to what my neighbors are going to say to me. And I have neighbors who are going to argue, we live in a culturally specific area because we've been here 10 or 20 or 40 years. Nobody should be allowed to perform, for example, timber cutting on here or build a place because we consider ourselves a culturally specific community. On the other hand, there are people who are foresters who say, wow, look, we have artifacts in these forests. We have log chains and bits and pieces of tools. How can, maybe nobody else will face this issue, but I expect to face the issue of people arguing before me that I should protect what they want to hold dear so that they can control what happens there and nobody else can. And that may not be the purview of this committee, but as a local elected official, it's what I deal with every day.
Yeah. No, that aspect of thank you, Commissioner. That aspect of culturally, what's a culturally specific community, I think we should continue to hold. I know Amanda's been wrestling with it for months and months. Flip back and take a peek at the BOEM definition. Reese, the BOEM definition uses culturally related group. So I worry, right? There's a number of worries I hold about some of these definitions and identities, but Reese, maybe you can help bail me out here.
Yeah, I definitely hear your concerns, Commissioner. We hear them daily, as well. And we, so I recognize that, and this is, and I don't want to stay focused on the BOEM one in its specificity. I think that it does have some elements, which is it is inclusive, meaning communities can opt in their own voice. As a representative of a tribe, it would be inappropriate for me to step in and speak for a place that has connection to the Chinese descendant community of those that dug the mine, put in the rails, or created small tight-knit communities that any more than I would ask anybody there to talk about the tribe. So I think that's why that language was written that way, is so that it's not one voice over another, and only those of an area or connection can actually speak to it. So maybe what we could consider as we're looking at it, developing this definition, is break it into its component parts. How is an area defined? Who does the definition? And then what happens? Because it's the what happens after that seems to be where the bottleneck is going to really be, and everybody's competing voice. And I think if we lay out a process for how to walk through those steps of the competing voices that keep the focus on whatever the action is, that keeps the steps in place. But again, I'm one voice here, and I generally will do a 3 count, and if nobody else has raised a hand, I generally do. So just don't call on me if you don't.
Oh, it's all right, please. Thank you. Thank you. Kimberly, please.
Yeah, I want to echo what a few folks have said already, but again, with my planner hat on, I want to say first that I do like the broadness of this definition, as it reassures me that it leaves it open for the people that need to have a voice, have a voice. Now, that said, I think it was Amanda that clarified that the definition itself is not where the work is going to happen. And I think that the work can and should happen in the later sections of the rule. And I'm thinking about, and I'm looking at Ed, but he can't tell that I'm looking at him. but the rules associated with National Register properties as an example. I think we could look to those as an example of how to more narrowly define the process itself and to clarify what local jurisdictions are responsible for and also what their alternatives are. And so just as an example of what happens in our jurisdictions in Salem, because we've been working without these kinds of rules, we have looked to the National Register rules to kind of guide us in what we're doing. And we're connecting what we're doing to our comprehensive plan through a historic preservation plan. So a way that we could provide guidance through the later rules is to clarify that local jurisdictions must define these cultural areas in their comprehensive plan, the way that we do for Goal 5 resources for National Register properties, so that it's predictable. So it's not like, oh my gosh, I have no idea what's going to come out of the sky. So I think go back to what you know, that's what I learned early on, what works, and also learn from what doesn't. So as with Brees, I'll always raise my hand too. So
thank you. Well, that's why you're here. So thank you. And I'm always thinking about the city or county planning commission and the city council or county commissions in front of whom these decisions will be. So we can think of those community members that will be struggling with this rule, and then also the public testimony. I know many, perhaps all of the tribes that have been, the representatives that are on this call have also worked in those spaces, working to get the attention of those planning commissions and city councils and county commissions. So there's a dynamic tension, if you will, of wanting to be heard and who the deciders are. So I would just say, be thinking of that. And then also in sort of the one pager we had in your packet, Amanda, thanks, I'll be quiet here in a moment, but in the one pager, we noted some guiding principles for the rulemaking. And one of that is to also be mindful of development timelines in Oregon. So this is a real challenge. The development timelines in Oregon are a decision or recommendation, and you can help me out here, within 120 days for a city and 150 days for a county. So let's be exploring those together as we go forward. That has nothing to do with the archaeological protections that Alyssa and John were speaking about earlier. They're wholly different. Those are statutes in and of themselves for inadvertent discovery. But in terms of development timelines, that's what we're trying to keep in mind. Our director and the governor's office is obviously a priority on housing in the state and production. Have multiple competing crises here in Oregon, and not the least of which is the loss of culture experienced by people to whom I'm not related, but the indigenous people of Oregon. So also the challenges of housing and climate change. So lots to keep in mind as we work through this together, to be as expansive and inclusive as possible, as well as to keep the basic framework of Oregon's land use planning system somewhat along with us as we move forward. It's going to be a challenge. We'll need every single person on this call, and maybe even John's cat, who I think just made a guest appearance, so I can blush. Ms. Punson, please.
A couple things that are continually in my head thinking about this. So one is something I was helped to be aware of in a presentation by some archaeologists who work on artifacts, evidence of Chinese Americans who, worked the landscape and whose history was largely unpreserved in written form because it was not considered important by the people who were writing the history. So what has been felt important to me about this rule writing is that it could be a way to capture those culturally identified communities. So to shrink that to be somehow communities that have been in Oregon whose history was not preserved by the history books. So just put that out there as something to think about, because that speaks to me. And then the other is that there is more work that we can do, and maybe everybody on the RAC can help do this, is try to talk with people who are in culturally identified groups, again, whose history was not preserved the same way. Some of these groups are doing a lot of work with historic preservation, because some of the places that are important to them are places that can be easily identified on the National Register of Historic Places. But this idea of the landscape areas, if maybe we can craft this definition and then keep it open while we get input from other people, and then maybe actually be specific to groups of people whose history was not well respected in the history of our state. And then I guess I also want to say that we could craft a rule where even if we don't get that input now, let me say one more thing, preface. So archaeological sites, I'm going to assume that archaeological sites are going to be a significant, or at least significant archaeological sites are going to be a significant Goal 5 resource. And those are culturally agnostic, right? Doesn't matter who left the pot or the divot or the whatever the tree, if it's a archaeological artifact, it is, we already have those protections, and let's use this rule to better inform people about the laws that we already have and rules we already have, and maybe get some proactive stuff going to be better protective of them. But then these other areas, if we can't get a really firm, if it is a list, it doesn't have to be the be all end all, because we can in the rule then allow local governments to add to that list if they are solicited by groups of people who come and say, hey, in this city we have this important place. This rule wouldn't have to shut that out if we can't identify everything we think we need to in the definition to begin with.
Amanda, thank you. Lots of food for thought. I don't see any. Okay. You think I can remember 2.5 hours ago and say Latife? I hope I hope I was warm. It's a beautiful name, so I want to get it right. Thank you.
Thank you. Yeah, I just wanted to offer, one of the terms that we utilize often is historically excluded communities, trying to move away from minority or disadvantaged communities. So like the historically excluded community, to really specify what we mean by the culturally specific communities part. And then also to echo that because there are the historically excluded communities, it feels important to get very maybe prescriptive in listing out what we mean by it, but it is not necessarily an exhaustive list. So how do we name the particular places, that what do we mean, but not necessarily say this is everything. So really creating both the opportunity for additional interpretation and also protect with specificity.
Thank you. Thank you. So it's a great suggestion. Something about your audio comes in a tiny bit choppy for me, so I'm just going to say to emphasize that historically excluded term that you were mentioning, and then also to spell out kind of what that means, but including but not limited, for example. tribal nations in Oregon, indigenous people, African American Oregonians, but well documented exclusion that has happened in our state. It's a painful history for sure, and it continues today. So thank you. I will just touch on, if I can, try to kind of bring it home here, and I'll offer Commissioner Thompson some last words as we go forward. See if I can get this computer to wake up here. Okay, so I just wanted to draw attention to the year, to our tribal partners who have been working with us on this for about 4 years since it's been in the policy agenda. I need to apologize and say we are in the final stretch here. And it will just seem all too fast after all that prep. Our directors asked that we wrap this up this year, not be trying to meet during legislative session when half our committee would go bonkers trying to keep track of us. So looking at roughly January, March, May, something really important happens there in June. Because we have this rulemaking advisory committee, we need to run draft fiscal impact statements by this group. So that will be for fiscal, housing, and racial equity impacts. So we'll need to sort of advance a draft rule to hopefully a consultant in that month for then your review and comment in July, before we go pencils down for internal legal review or director's review in August, and then on September 1, publishing with Casaria's help and Elliot's help, publishing with the Secretary of State, formal notice of public hearing. And then the commission's hearings are set to be, you see them there, September and December, before the session starts in January. So it is ambitious. Just appreciate everyone's grace as we move forward together, and do use written as well as verbal communications. Our next meeting, we're looking at the weeks of 11 and 18, and Elliot probably will be preparing, or if he has already, a doodle poll with those dates. We have Commissioner Thompson's dates and our staff dates that want to get those out to you. I do want to commend everyone to the Legislative Commission on Indian Services website resources that Director Flanagan mentioned. That is an amazing resource. So please, it's in the packet, it's in our email. Please go ahead and just review those education and consultation sections. They're deep and very good. I think the only other thing I'll say is, if someone might be wondering about a technical assistant, a technical advisory committee, Amanda does have a very specific a need for some guidance from a technical perspective. So I'll let her kind of mention what that is and let's gather that together. But I don't want for any reason that to seem exclusive to the conversations we need to have that Ariel called our attention to, which is forums to which all manner of local government, city or county folks could attend, probably via some webinar function. But I really like Ariel's call to minimize surprises on this. This is difficult enough as it is without the people being kind of taken off guard. So appreciate city and county representatives helping us get the word out so that we can take a close look at that impacts and make sure they're known and well resourced. To know that there's just one John and one Alyssa in this state gives you an idea of how under-resourced we are in this area. And there was no Alyssa 2 years ago. So that's, definitely we'll be needing to work through those issues together. Commissioner Thompson, any last words, or should we call up any last words from a RAC member and then you can be that fighting voice? Yeah. Anyone else from the RAC want to get some guidance in here for us, please, Nick?
Yeah, could you just elaborate? I wasn't quite following. So is there a TAC already stood up, or are you still?
Yeah, thanks, Dave. Amanda, do you mind
Sure.
mentioning what's in your mind there? Thank you.
Yeah, and I will acknowledge this kind of push and pull about the TAC. What I need is a TAC that will help really work out and understand this intersection between whatever our rule might do and the existing archaeological rules and statutes. So that's what I'm thinking. And so people who have maybe, and we don't, to accomplish that, I don't think need a big room of people. I understand that there's other people who want to participate in the conversation. So that's the tug there. But my task that I see for the TAC is that dovetailing of the archaeological rules and what this rule might ask of local governments. If other people have other thoughts of what a TAC would need to dig into, then raise those issues, and then we can figure out who we need to have in the room.
And a TAC can be quite poor, so I do want to honor Amanda's need. And there's different models of how to run a TAC, or a focus group, or a subgroup, or a work group. So let's not get hung up on that. Let's just identify the things we need to work through together, and we can figure out the right forum from that. For example, advising local governments, that's a big one, and that's not just a TAC, right? That's not just a TAC. The climate rulemaking advisory group recently had a TAC that was completely porous, but I think that would drive Amanda up a wall. So I want to make sure we find the right balance of the right forums at the right time. So please do stay tuned on that. But to form this specific TAC, thanks, Nick, we would put out the kind of mission of this and ask for RAC members with this kind of specialized expertise in that application to join Amanda in that. Thanks, Nicholas. Commissioner Thompson, please, last words.
Well, I think we are well begun. I think that this is so complex and so, at this point, malleable. And as we confer, we'll decide where the boundaries need to be, what filters need to be in place, what dimensions will need to be measured, and that's how we'll proceed together.
The key word, together. Thank you.
Together.
Thank you, everyone, very much. Feel free to send us comments, and we'll get our next meeting doodle poll out soon. I just really, really appreciate everyone's time today. We couldn't be more grateful.